Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Radio. It is July 6th, 2024. This is our July 4th weekend, and I want to wish patriotic compliments to all of our people in the armed services. As you know, this program comes up every Saturday at 3 p.m. We do have it live on YouTube now, and it will be posted on my website or on YouTube after this presentation is over. We normally will open it up to questions from those people who are in the Zoom meeting, but I always start with an opening topic. So what's the opening topic today? And that is strategies for raising rents on rent control units. Strategies for raising rents on rent control units. Now, we all know that the city of Los Angeles and, of course, unincorporated areas of LA County have allowed now for a 4% rent increase if you haven't raised the rent in the last year. The state of California, as of August 1st, under statewide rent control, will allow an 8.9% rent increase, and different other municipalities that have rent control determine what percentage you're allowed to raise the rent. So the issue is, if you are subject to a rent control statute, either statewide or a local rent control statute, is there any way that you can get your rent up to market level? Or are you just stuck with that percentage that they give you, 4%, when you know that the premises are thousands of dollars potentially under market level? So the issue is, what can you do? So I had a client call me, this is last year, and it kind of stuck in my craw. And in that phone call, she said to me, Dennis, I'm really suffering under rent control. My rents are way under market. I could get another $700-800 for this one particular unit. But of course, I know this tenant is never going to leave. So what can I do? So I just happened to say, well, does the tenant owe you rent? And she responded, oh my God, he hasn't paid rent in 3 months. And I was struck to myself that, wow, if you have a tenant that is under market and that tenant is not paying you rent, then you need to immediately go forward and serve that tenant with a 3-day notice to pay the rent. If the tenant doesn't pay within the 3 days, then you have the right to bring forth an unlawful detainer. And when that tenant vacates the unit, you have the right to raise the rent to market value. So one strategy is clear. If a tenant owes you rent, even if it's a small amount of rent, you want to immediately serve a 3-day notice. Now, you can be lenient where the rent is market value and the tenant says, hey, I'm going to pay you next week. Okay. But if that tenant, owes you $25 and you're in the city of Redondo Beach, and you could get $700 more, you want to serve that 3-day notice for $2,500. I don't care how small it is. You want to immediately proceed with that notice. Because if you don't, then what's going to happen is that tenant's going to be able to stay, and you can't get market value. So these rent control statutes, these local municipalities and the state of California reward you if you evict a tenant for non-payment of rent, because if you can serve him a 3-day notice and he doesn't pay within the 3 days, then there is no obligation. Even if he comes with you with the rent gift wrapped on the 4th day, there's no obligation for you to accept that rent. It's called a 3-day notice to pay rent or quit. It is not called a 3-day notice plus whatever the hell I feel like, okay? So if a tenant owes you rent, please immediately serve them with a 3-day notice. Now, we know in the city of Los Angeles, And in unincorporated areas of LA County, you have to make sure that you serve the 3-day notice if the amount in the 3-day notice exceeds the threshold. Now, that information is on my website at evict123.com. But for example's sake, if it's a 1-bedroom, you need to serve the 3-day notice if it exceeds $2,006. For a 2-bedroom, you need to serve the notice if it exceeds $2,544. So therefore, if the rent is only $2,000 for a 1-bedroom and the tenant wants to pay you a partial, don't take it. Because what you're going to do is you're going to wait till the second month, and by the second month, they'll owe you $4,000. So if you are in those 2 jurisdictions, unincorporated area of LA County or the city of Los Angeles, make sure before you serve that notice that you're above the threshold. Now, when can you serve a 3-day notice to pay the rent? And the answer to that is the day after rent is due. People always say, well, there's a 3-day grace period. There's a 5-day grace period. That doesn't exist, ladies and gentlemen. Grace periods are only when a late charge kicks in based on the terms of your rental agreement. If your rent is due on the 1st, you can serve a 3-day notice on the 2nd. I don't care that the 2nd is a Saturday or a Sunday or a legal holiday. If the 1st was a Friday, you can serve that notice the next day, okay? And that includes the example I always give, if rent is payable on the 24th of each month, and in the month of December, that turns out to be a Tuesday, can you go over there on Christmas Day, the 25th of December, and serve, which would be a Wednesday, and serve a 3-day notice? The answer is yes. Would you be crazy to do so? Yes. But could you legally do so? Of course. So you want to make sure that you serve that 3-day notice immediately, because for an apartment where the rent is so under market, you don't want him to pay the rent. What you want is for him to miss the payment. So you're going to serve that notice as soon as you can, right after the rent is due. However, if the due date does fall on a Saturday, Sunday, or judicial holiday, the tenant would get through the next business day. So let me explain that one. If the 1st of the month when rent is due is a Saturday, then that means the tenant's rent is not due until Monday, which means you can't serve a 3-day notice until Tuesday. So figure it out, take a look at a calendar, serve those 3-day notices immediately where rent is way below market value. This is your best chance, your best strategy of evicting the tenant. Now, how do you know when the 3 days are up? How do you count days? Most people say, what are you talking about? 3 days, 1, 2, 3, but it's not that easy. The day you serve the notice is day 0. So if I'm serving a notice on Monday, Monday is day 0. I don't care what time of the day you served it, it's day 0. The day number 1 would be Tuesday, day number 2 would be Wednesday, and day number 3 would be Thursday. So the tenant would have until Thursday midnight to pay you. If he comes to you with all the rent gift wrapped on Friday, do not accept it, because this is your best chance of evicting the tenant. Now, what happens if you serve the notice on a Friday? Well, Friday we know is day 0, but you see, when counting days, those days have to exclude Saturdays, Sundays, and judicial holidays. So therefore, Saturday, if I served it on Friday, Saturday would be nothing, Sunday would be nothing, Monday would be day number 1, Tuesday day number 2, and Wednesday would be day number 3. So we'd have till Wednesday midnight to pay. You don't have to accept it if it's beyond that date. Okay. Now, with regard to the thought process of when to serve that notice, think about it. If you serve a notice on Friday, Saturday, or Sunday, it makes no difference. The tenant's going to have until Wednesday to pay the rent. So be sure that you immediately jump on a tenant who owes you rent. That's your best strategy. Make sure that you immediately serve the notice the day after rent is due. And we know the exception with regard to when rents are due. And we also know when would be the last day that we can accept rent. Now, are there other strategies involved? And of course, the answer is yes. Main ones that we use are that there are other violations of the rental agreement. So you have to have a rental agreement, and we're talking about something other than rent. If the tenant violates a substantial term of his rental agreement, that would be grounds for eviction. In that situation, you would immediately serve a notice to perform or quit. These notices are on my website, and the tenant would have 3 days to correct the action. By the way, if you do serve that notice, do not accept any further rent ever. So let's pretend they bring in extra persons. Let's pretend they brought in a dog or a pet giraffe, or let's pretend that they altered the premises. Maybe they took down the smoke detectors, okay? Maybe they installed a satellite dish on the roof. Maybe they did surveillance cameras on the exterior of the property. These would all be alterations, and under most rental agreements, if in fact you make an alteration, you would have to first obtain the approval of the landlord. And if you don't obtain the approval of the landlord, then that would be a violation. We would serve a 3-day notice to perform or quit. And at the end of the 3rd day, if the tenant hasn't performed, if that dog is still there, and I don't care whether you like dogs or not, we're talking about strategies for increasing rent. If that dog is still there after the 3rd day, we have the right to bring forth an eviction to evict everyone from that unit. And guess what? The city of Los Angeles and all those other rent control jurisdictions is going to reward you. They're going to state to you that you can now raise the rent to market level. So that's one other strategy that you can employ. However, there's one more, okay? There's one more strategy, and that strategy deals with a concept. So here's the concept. If I told each and every one of you who are listening to me that if you gave me $30,000 each, that I would give to you guaranteed $1,500 a month for the rest of your life. Once again, you give me $30,000, a one-time payment, and it is guaranteed, etched in stone, every single month for the rest of your life, I will give you $1,500. Now, if you believe that was going to happen, you would absolutely be a fool not to take that proposition, because the return on your investment is extraordinary. Well, I don't have that deal. Don't give me your money, because I'm not giving you $1,500 a month for the rest of your life. But I can tell you that you might have that deal. If you've got a tenant where the rent is $1,500 and you could get $3,000 for that unit, an additional $1,500, wouldn't it make sense to offer that tenant $30,000 to move? In other words, what I'm talking about is a voluntary vacate agreement where you're paying the tenant to move. And people will say, gee, that's crazy. I'm going to pay this tenant $30,000. No, ladies and gentlemen, you're crazy. If you don't offer this person $30,000, look at the return on your investment, $1,500. And this is guaranteed because you know yourself that the rent, which is currently $1,500, can be raised to $3,000. You're going to make $1,500 a month. So this is an important strategy that you can use to encourage tenants to move by paying them to get out. Now, of course, you need to have a proper voluntary vacate agreement. And I happen to know a law firm which really protects you in these agreements. But notwithstanding that, make a deal with your tenant. If you make a deal with your tenant, then you'll be in a situation where you get rid of the tenant, you can raise the rent to market value, and now you're going to get your return, in my example, $1,500 per month. Okay, ladies and gentlemen, that's my talk for today. I'm going to open it up to questions. We all know the ground rules, and the ground rules are pretty simple. That is, this Zoom meeting, this YouTube Live, is for informational purposes only. It's not a substitute for getting quality legal assistance. If you do want to talk to me, it's really simple. Raise your hand electronically. It's in the toolbar, in the Zoom toolbar, and I'll be happy to talk to those people who are in our Zoom meeting. And last but not least, If you have a lawsuit currently pending with my firm, please do not ask me specific questions on that. This broadcast is only for general questions on the law. And on that basis, I'm going to open it up. I see our first participant is Janice Lignetto. I'm going to ask you to unmute yourself, young lady.
Hi, Dennis. How are you doing? I want to thank you for that change of ownership form and change of management. Question about it. Does that have to be served a certain number of days before a lease expires, or is it just if it any amount of time before it expires?
No, it becomes effective the moment you serve it on the tenants.
Okay. And then the other question is, do you have anything to say about strategies concerning Proposition 33? I know earlier you mentioned the Section 8 issue, month-to-month leases. Does that change your thinking at all about?
Tell me what Proposition 33 is.
Isn't that all would essentially be statewide rent control, including single-family homes?
Well, right now, maybe you're talking about the Justice for Renters Act. Is that what you're talking about? That's on the ballot?
I don't know what it's called. I just read it.
Well, I mean, there's going to be something on the ballot which is going to try to take away or repeal Costa-Hawkins.
Right.
And Costa-Hawkins guaranteed that if you had a single family home or a townhouse or a condo, notwithstanding anything in your rental agreement, you have the right to raise the rent to market level. So we all need to be diligent to make sure that we vote. We want to vote against the Justice for Renters Act. What is this? By the way, what is this thing, Justice for Renters Act? Everybody goddamn knows that every law is in favor of the tenant in the state of California. It's absurd what they're doing to income property owners. So they're calling this justice for renters. We need justice for landlords, ladies and gentlemen. Anyway, thank you very much for your question, Janice, and we are going to move on. I'm not sure who this is, but I think it says just Jay. Jay, I'm going to ask you to unmute yourself.
Hello.
Hello.
If I have 3 individuals on a single rental agreement, am I exempt from statewide rent control?
If you have 3 individuals on a rental agreement, that would have nothing to do whether you're exempt or not exempt from statewide rent control. What city is your property located in?
It's in the city of Antioch in Contra Costa.
Okay, I'm not familiar with that area. However, is there more than one unit on the property?
It's a single family home.
Okay, so a single family home is not subject to rent limitations, and it's not subject to statewide rent control, but you have to have a phrase in your contract. When did these people move in approximately?
About 5 years ago. Originally, they were on separate rental agreements, but I was told that wasn't allowed.
Okay,
and
so they moved in 5 years ago. When did you do the last rental agreement?
In 2019, around there, or
Perfect. There's a form on my website which you need to fill out and send immediately. It's notice to the tenant that this property is exempt from statewide rent control. It is legal to fill it out now. So go to my website, evict123.com, go to the free form section, and you'll see statewide forms. You want to pick the form that says notice property exempt. You want to serve that on your tenant, because in that situation, you're not going to be, as a single family home, you're not going to be subject to statewide rent control, which means you can always raise the rent to market value. But right now, if you wanted to just serve on them a 60-day notice to vacate on the basis that maybe you want to sell the property, you would be free to do it. You would not be free to do it if you don't serve that notice. So head on over there, young lady, and do it. I'm going to move on to a favorite, Jim Polina. How are you today, sir?
Thanks, Dennis. Nice to see you again.
Always.
Okay, I got a couple questions for you. And this is pretty wild. At least I was shocked. I had a friend going through an eviction as a tenant. She hired an eviction company, not yours. Very important, not yours. Her attorney negotiated with the landlady's attorney for cash for keys, voluntary vacate agreement. It came up with a dollar amount of $27,000, which my understanding is pretty low or average today. Shockingly, For me, that's very high. But here's the shocking point. Her attorney got 30% of it. Is that normal?
Well, it all depends. The deal that you set up with your attorney, a lot of times what happens is these attorneys don't charge the tenants because they're waiting for a payoff at the end. I mean, that's true. Like if you get into a traffic accident, that's not your fault. You hire an attorney that you don't pay the attorney anything. It's, based on a percentage of what is received. So I think that's pretty normal
Okay.
in a situation like that. And again, that would be contained in her retainer agreement with the attorney.
Yeah, it was. I just didn't know about that. Okay, here's question number 2. And you mentioned this before. People renting unpermitted living spaces as a separate unit. The tenant can request all that back rent paid back to them, refunded to them. So, and then you said there's a big difference if there is a doorway between that self-contained unit and the rest of the house. So my question is, as long as there's a doorway there, the tenant cannot request, it's unpermitted as a separate unit, but there's a doorway with a kitchenette and a bathroom and an exterior entrance. Can the tenant request refund of rent?
Well, first of all, I don't think the tenant can request a refund of rent, even if it is a totally illegal unit. There's nothing in the law that says that, though a lot of tenants' attorneys do try to state that you have to pay back all the rent that you paid because you were in an illegal unit. I don't see that as the law. However, notwithstanding that, if you have a doorway, you might have it's not considered an illegal unit. It might be considered an illegal part of the house, but it's not an illegal unit. So as long as they keep the doorway there, then it's really not considered to be an illegal unit, which would, for example, in the city of Los Angeles, would trigger a bunch of relocation costs.
So that renter would be considered a roommate?
At that point, yes. But again, it's not an illegal house. There's just a door that's closed. You might have an illegal kitchen in the house because they put an extra kitchen in there, but it doesn't make it an illegal unit.
Right. So what kind of lease agreement do you have with a roommate?
I would just do a regular rental agreement. I'm not a big fan of chopping up a house and closing a door and putting in an illegal kitchen. What you need to do is just rent the entire house out as a legal unit. But again, if you're telling me that somebody's already done that, obviously a standard rental agreement, but again, I don't see that's triggering them to pay relocation money, and certainly doesn't trigger a situation where they would have to repay all the rent that the tenant originally paid.
Thank you, Dennis.
Thank you, sir. Hey, Fred Morris, I'm going to ask you to unmute yourself.
Hello, Dennis. How are you?
I am fine.
All right. Quick question. So I have a tenant in Long Beach. She's a pain in the butt. There's no rent control there. She's been there for 6 years. So during the COVID era, she took advantage. She brought in a pit bull without our authorization. And she also like about 2021, a year later, after she brought the dog, she put laminate floors on top of the floors we already had in there, also without our authorization. And we did send her a letter in regard to that, but obviously during COVID, you couldn't do anything. Fast forward now, we gave her a rent increase, which was 6 months after her due date. She got mad. She called the city of Long Beach. I have to meet with the inspector next week. One of the items he has in there is the crack in the laminate that she put on top of ours, which was pretty stupid. Now we're forced to change that laminate and top of that what she put in illegally. I guess my question is, with her pit bull, are we too late to try to evict her, since she brought it in COVID and now? Okay.
No, you're not too late. We can serve a 3-day notice for the dog. We can serve a 3-day notice for the alteration that she did with regard to placing laminate over the floor. So what I would do is serve that 3-day notice, giving her 3 days to get rid of the dog and 3 days to pull up that laminate and restore the floor to its original condition. If she doesn't do that, you've got a wonderful case for eviction, Fred.
So from your experience real quick here, how hard is it? Because I hear a lot of my friends that they tell me it takes 6 months, 9 months. What's your experience for rent control versus non-rent control for situations like this?
I don't
get them out.
I don't think it matters between rent control and non-rent control. We're quoting about 2.5 to 3 months. The biggest delay is the sheriff's office, which is taking about a month and a half to do a lockout from when we win the case. So, but again, you've got a wonderful case for eviction. And with that, young sir, I am going to move on to Austin. Austin, say hello.
How you doing, Dennis?
Can't complain.
All right. Two questions. So first one, I officially took ownership of a fourplex in the city of Long Beach. And I'm going to be moving into one of the units pretty soon. So I joined the club. I'm a landlord now. And my question is, I did the change of ownership for all the tenants, but two of the tenants, two of the units have been there for a while. Do I need to serve them a TPA change of terms saying that they are protected by TPA?
This is in Long Beach?
That's correct.
Okay, Long Beach has their own rent control, so there's nothing to serve there. I don't believe they have any specific notices. And you are under their statute. Their statute does mimic the AB 1482, but there's no additional notice that needs to be served on them.
Okay, that's good. And the other quick question is the tenants are actually in dispute with the neighboring property over a prescriptive parking easement. And my question is that something that your law firm can offer counsel on, or can you recommend?
So is it you who's claiming that you have a right to park on the other person's property?
My tenants are.
Okay, well, let me explain. Why do you care? Who cares? Let them duke it out with the thing. It has nothing to do with you, and you want to stay out of this. Does my firm handle these matters? And the answer is no. But I would still stay away from getting involved in your tenant's dispute with other property owners. It's enough that you have to deal with your own tenants.
Thank you, Dennis.
All right, you take care. Good question. Okay, now I see Nancy. Nancy, how are you today? Are you there, Nancy? Nancy, I'm going to ask you to unmute yourself.
Can you
there
hear
go.
me?
I can, young lady.
Yes. Hi, Dennis. How are you?
I am good, thank you.
Okay. I want to make sure you hear me. Okay. I am currently owner in city of Santa Monica, and I have a tenant get a doctor document and saying that she cannot move. In other words, she have a mobility problem. And she cited that under section AB 1620, she have the right to move from upstairs to downstairs unit. Now here is the problem. The downstairs have a balcony, but the upstairs does not, a patio rather, or storage space that are outdoor, but the upstairs does not have it. And she want to move it downstairs. So do I have to do it, or what is the problem if I don't do it? And the unit currently available, and I'm withhold on it because I don't know what to do.
Well, technically speaking, this law that just recently passed that says that if there is a similar unit in the building and somebody with a disability requests that unit, then you have to allow them to move into that unit at the same price as what they were paying. The fact that one has a balcony and one doesn't have a balcony, I don't think that makes much of a difference. We're talking about, it does have, I presume, the same amount of bedrooms, correct?
Yes, but the one that have the patio or extra storage outside, which is not even involved in the unit, can I take that patio?
Yeah, I would have to see what's going on with that, but generally, yeah, you don't have to give them the patio. The patio is probably common area space. So a similar unit would not have the patio, so you could take that patio. I don't see a problem with that.
Okay, even though it's the outside, she cannot. Okay, what if she want to then rent that patio separately? Can I do that?
How are you going to rent that patio separately? This I got it here.
because there is a
Are you gonna
registered
rent it to a
place.
homeless person to pitch a tent?
No,
Yeah.
no, I mean to her. She offered to rent it.
Oh, I see what you're saying. Yeah, I think you could do that. Yeah.
Okay, it's not illegal, right? If I'm
No.
doing that.
No, because you're giving her a similar unit, so I think you're fine with that.
Okay, thank you.
All right, you take care. All right, let's move over to Julia Jordan. How are you?
Hey Dennis, I'm good. How are you?
I am fine, thank you.
Good. I'm gonna talk quick. My battery's getting low. So I have a tenant who has accused us of not charging the correct rental percentage. And long story short, I charged her for a 4-unit. The city came in and said, you have an illegal tenant in a space that was a storage, and they classified it as a 5-unit. So this particular tenant says, you charged us rental increases over the last 3 years.
Wait, hold on a second. First of all, what city are we talking about?
Okay, so we're talking about the city of Inglewood.
Okay, I'm not aware that Inglewood has a difference between 4 or 5 units.
They do,
Okay, so they have a different tier for increasing rents if it's 4 or 5?
correct.
Okay, so let's pretend that you really only had a 4-unit building because that's what you legally have in there, because one of them was illegal, then I think the city would be correct in saying that whatever that rent increase that you were allowed should have been for a 4-unit because you have only legally 4 units there. So you're gonna have to disgorge any additional rent. I'm not aware of that rent increase for 4 versus 5 units in Inglewood, but assuming that's what the law is.
Yeah, they're classifying the 4 units or less as being controlled by the state and 5 units or more as being,
Well, then, yeah, then you're 4 units.
okay. Well, so we're in negotiations about what they think that we owe them. And so this is my real question. So I'm trying to work with them and the city. But the question is, let's assume that we come up with a new basis for their rent based on, what we're being accused of. They want to enter into a new lease effective August 1st at this new rate, whatever that is. My question is, the city of Inglewood does not consider a tenant having just cause rights for the first year. So if I gave them a new lease, would that be considered a new tenant?
No, you would still be under good cause because they've been there longer, even though you've entered into a new rental agreement. That's an interesting question. I'm gonna have to look up that law. You have all these municipalities, there's like 12 or 13, and they all have their own rules. So I wasn't aware of that particular one because it just doesn't come up in our practice. But yeah, that would be considered a 4-unit, but the fact that they enter into a new rental agreement doesn't mean that their tenancy started there, so they'd been there less than 1 year. Anyway,
Okay.
good question, Julia, and we are going to move on to Amir. Amir, say hello.
Hi, Dennis. Thank you for
Hello.
your time. Hi. Can you hear me?
Perfectly.
Awesome. So I have 3 questions. Number 1, we are buying a duplex in city of Los Angeles in Boyle Heights. And one of the duplex, one of the tenants had violation with the previous owner. And previous owner,
What's the violation?
graffiti and pit bull, which they are not allowed to keep the dog in the premises, and they damage the garage as well.
Okay, but you're just buying the property, you don't own it yet?
We are closing on Friday.
Okay, so you can at least start the case based on the dog. I don't see a problem with that. The rental agreement, I presume, says no dogs, right?
Yes.
So I would go on that basis on the dog. As to the graffiti, see, the damage didn't really happen on your watch. So I would probably have a problem with that. And it's also going to be difficult to prove that this tenant did that.
Graffiti, they have a covered garage, and basically they have a private space for their car. So they are the only one that have access to go inside that
Yeah, but
space.
somebody broke in one day and I didn't do it. Now
I
what are you
see.
gonna say?
And they broke the wall, and there is a police report between the other neighbor because the guy who was on a drug broke the wall and he thought someone stole his dog, and which he thought that's a neighbor. They park next to them. So my question was, am I able to use their, because I know the current owner served them with 3 days notice. And
Yeah, I think it would be problematic if we just went on the damage to the unit or the graffiti. However, if we're gonna go on the dog, I think that's a viable case. And on that basis, we can put more bullets in our gun, as I like to call it. So I would probably add those other two items, the graffiti and the damage to the door. But again, I wouldn't rely on that solely, but it's not bad to put that in.
awesome. So my next question is, we are buying property and we do LS Act because we are going to demo the property for affordable housing projects. And my question is, for cash for key contract, which we were doing for past couple of years, we were serving tenants with a tenant's right, which it says how much they are going to get if they take us to the court. And let's say right now the amount is 24,000 something. We agree with the tenant for $10,000. They agreed, they signed. We put the money in escrow, notarize it, and we give them rights to come back to the property after we build the property. Is there any chance they got to come back and sue us?
Okay,
Even
you're
though-
mistaken that there's a specific amount that's required if you do a voluntary vacate agreement. There is no specific amount. It could be, would you move if I give you a ticket to Disneyland? If he agrees to that, that's a valid contract. Or he could say, no, I want $100 million. Okay, I'll give you the 100 million. It's anything in between. So there is no specific amount. You can come to any terms. If we're talking about the city of Los Angeles, there is a disclosure form that has to be given to the tenant, and they have a 30-day right to cool off. And then that has to be sent into the city and also your voluntary vacate agreement. The problem with these agreements that most people use is that there's no way to enforce them under the law for the city of Los Angeles. For example, if the tenant, it's been more than 30 days, everything notarized, every procedure followed with the city, and if the tenant doesn't move after he's got the money in his pocket, can you bring forth an eviction? And the answer is no, you can't. And the reason why you can't is that there's 12 reasons to evict, and failing to move out on a vacate agreement is not a reason to evict. That's why we have a special agreement that we do, which allows us to evict the tenant, notwithstanding the fact that there is no ground to evict the tenant specifically for that reason.
I called your office and they refer me to talk to Jennifer.
Mm-hmm.
And unfortunately, I tried a couple times. No one.
Well, call between 7 to 8 a.m. and hit my extension 1001. You can only use my extension between 7 to 8, Monday through Friday, and I'll get you in touch with Jennifer immediately. Again, as soon as the recording comes on, hit that extension. If you use that extension at 8:01, I will violently hang up the phone.
Okay, I understand. And thank you very much.
All right, thank you, sir. All right, we are moving on to a cell phone number that ends 8071. If you are on a cell phone, which I don't think you are, it's *6, otherwise unmute yourself. Ms. or Mr. Cell Phone ending 8071. I'm going to ask you to unmute yourself. Okay, we're going to move on to Eric. Eric, I'm going to ask you to unmute yourself. Mr. Eric, please. There you go.
Thank you, Michael Dennis.
No problem.
Earlier, you talked about the time frame to evict a tenant. However, you broke up in the video when you mentioned the time for the sheriff lockout. How long is the sheriff taking?
I just think I said that in this broadcast. They're taking about this is LA County, okay? I don't want to disparage other counties, but LA County needs to be disparaged. And it's taking at least a month and a half to 2 months for them to get around to finally giving us a lockout date, if we're lucky.
Excellent. Thank you so much.
Okay. All right, we're doing pretty good here today. Getting through all of our questions. And let's see. Let's move on to Diana D. I'm going to ask you to unmute yourself.
Dennis,
Hi.
hi, how are you?
Can't complain.
Good. Dennis, you were just talking with Amir about the Ellis Act, and last week I'd asked you a question, and I think I've got the acts confused. I have some single-family properties in City of LA that are the land is actually zoned for multiple residences, and I think one of them is zoned for manufacturing, but that I think the manufacturing zone can be used for multiple residences also. So on that, I think you told me that that would just simply be by taking it out of the market to build more property, that would just be a 60-day notice and 1 month relocation. Is that correct? And
Yeah,
I
for
was
a
just
single
thinking-
family residence, it's either renovation or it's under the permanent removal. But in either event, it's a 60-day notice and the relocation is 1 month's rent.
Okay. Okay, thank you very much.
You're very welcome, young lady. And let's take a look. Okay, Kathy, you say hello.
Okay, hello. Thank you, Dennis. I have a situation that the tenant's lease expired on July 31st. And then, she gave me a notice on July 5th that he's going to move out at the end of July 31st. Now, on the lease form, they're saying that they need 30 days notice to notify the landlord to move out. So if he move out, can I charge him that 5 extra day on the refund of security deposit?
Most rental agreements, and I would have to see yours specifically, but most rental agreements state that if you're on a month-to-month tenancy, then you need to serve a 30-day notice. But if a lease expires by its own term, then the tenant doesn't need to give you any notice. They just have to inform you at any time, hey, my lease is over at the end of this month and I'm out of here. So, and you had notice of that because you rented the premises to them, presumably on August 1st of 2023. And by renting it on August 1st of 2023, you knew at that date that the lease was going to be over. So unless you had some specific language in your lease, which I would doubt, the tenant was proper in just telling you on July 5th or July 10th or July 20th that I'm not renewing the lease, and you cannot deduct anything after that lease expires for rent.
I have an addendum that they signed that they will give me 30 days notice. But I guess addendum is not in the lease, so it doesn't.
Well, no, addendum is in the lease, and if it said that if you intend to vacate at any time, even during the lease term, you've got to give me a 30-day notice, then I'm in agreement with you. But I'd have to look at the exact terminology that was in the addendum. An addendum is really just an extension of the lease. It's all one lease. The lease plus the addendum, that equals the lease.
Okay. Well, the addendum just saying that, tenant need to give 30 days notice to move out to the landlord. Is it good enough?
I don't think so. I think it would need to be spelled out that the lease is going to expire on July 31st. And if you are intending to stay beyond the expiration of the lease, then you need to, or intended to move at the expiration of the lease, then you need to serve a 30-day notice, 30 days in advance. I don't think you have that language in there. I don't think it's going to work.
Okay, thank you.
All right, Kathy, we are moving on to Catalina Salazar. How are you?
I'm great. How are you, sir?
Good. I like people that
Good.
show their video, as opposed to staring at a name on a screen.
Oh, well, thank you for that. I like it too. Hey, so I have a Section 8 property in Hacienda Heights, which is LA County unincorporated. 2-year tenant. She notified me a couple months ago that she has roaches. She has denied the exterminator access to the house at times. Very chaotic situation. So today I was gonna go and do some repairs there, notified her last week. She actually called the police on me today because she said that I don't have any business being on her property.
Well, let me slow you down on a couple of things. Number one,
Yeah.
technically, when you're going to serve an access notice, you don't do it to come in on a Saturday or a Sunday or judicial holidays. You need to do it during normal business hours, Monday through Friday, 9 to 5.
Got it.
If she tells you can't go in, it doesn't really make a difference. Show up with your pest control company and see if you can gain entrance. If you have a key, use the key if she doesn't open up the door. If you don't have a key, you can use a locksmith and go on in. If she stands in front of the door, obviously you're not going to push her aside and go in. But you might want to video the situation where she's standing there and not letting you in. You might want to put exactly on your notice to enter the dwelling, which is a form that's on my website. Put right on that form that you've denied my access in the past. If you deny my access this time, I will immediately be filing an unlawful detainer. Please allow me access so you don't have to be evicted. I put that right on the notice, and if she doesn't, then give us a call and we'll start an eviction.
Fantastic. And then you mentioned something earlier about violations. She did install a Ring camera. I didn't think of it as an alteration, but from what I think I heard you say, that is an alteration to the home, which yeah, I'm sure she had to drill or something.
That would be grounds for eviction.
Okay,
We've
good enough.
evicted
So
on
that's a
the
3-day.
3-day notice to perform or quit. What city was this, please?
It's in
You said
Hacienda Heights.
unincorporated.
Yeah.
Unincorporated area of LA County, believe it or not, is not a 3-day notice to perform or quit. They require a 10-day notice to perform or quit. And you
Okay.
also, within 5 days of the service of the notice, you have to send that 10-day notice in with a proof of service to the county of LA.
To the county of LA. Okay,
Yeah.
so I will. So on your website, is there a 10-day or would I just modify the 3-day?
You'd have to modify it. I do have the address, I believe, on the website. Let me see if I can pull that up real quick. Right here. It's in the free form section. And then it says, where would that be? Oh, special requirements for municipalities. That's in the free form sections. Click on that. And if you go down, it does say that for a notice to perform or quit, it's a 10-day notice. It says that you have to mail a copy of that 10-day notice and the proof of service to the Department of Consumers and Business Affairs, 320 West Temple Street, room G10, LA 912. But that is on my website. Look at me go. Okay.
I love it. Thank you. Thank you very, very much.
All right. Anyway, nice seeing you, I might add.
Have a wonderful day. Thank you.
Okay, we're moving on to Steve Nemeth. Say hello, young sir.
Hello there. Can you
Hi.
hear me? Hi. Is it legal for a landlord to not consider a HUD tenant or a Section 8 tenant?
No, the crazy laws for the state of California state that if confronted with an applicant who is asking you to allow him to move in with his Section 8 voucher, that you cannot summarily reject that application, that you do have to allow him to take at least an application. They've also made the law, because normally what I would have said in those cases is just run a credit check on the person. His credit will be bad and you can reject it. But as of January 1st, 2024, this year, they stated that you can't use credit as a method for rejecting the applicant for Section 8. It has to go on, quote, his ability to pay, which means that if he can pay the paltry share that Section 8 is asking him to pay, like $200, if he can demonstrate that to you, then you have to allow for the Section 8 tenant. However, and I've said this in previous broadcasts, there's a trick, so you never have to take a Section 8 tenant. And that trick is, from this point forward in time, no matter who you're renting to, Section 8 or not, you will only rent on a month-to-month basis. You will only rent on a rental agreement month-to-month. Section 8 will not allow a tenancy unless it's at least a 1-year tenancy. So no problem. Whether you're a Section 8 tenant or not, I'm renting only on month-to-month basis. That will save you, young sir.
Thank you.
Okay. Good question. Sandra Bagnall, I'm going to ask you to unmute yourself.
Hi, Dennis. Yay, I'm finally on.
Hey, look at you. Thank you
Okay,
for
so
viewing video of yourself.
oh, thanks. So I'm in Apple Valley. Our property is in Victorville, California, and our court is in Barstow. So anyways, talking about that that whole 3-day pay or quit. So we just served our tenant our 3-day pay or quit on June 29th. And so Wednesday it had already expired. And so I'm going through the process that you had just discussed. And so I went ahead and picked up the paperwork at a local courthouse, and I'm reviewing the paperwork because I want to get this ball rolling. And I plan to do the unlawful detainer and eviction and submit this by Monday. So as I'm looking at the form, I'm looking at UD 100 form, and it has some kind of specific questions, just a few quick questions. So both my mom
I
and
can't fill out the form with you, my love, on this broadcast.
Oh,
It's too technical.
okay.
You might want to call the office. I can tell you categorically and
Mhm.
prove me wrong and tell me so that when you file these papers, they'll be filed wrong. And you'll have to start all over again. It's just the nature of the beast. They make these things so difficult and
Okay.
confusing. So I can't really go over the form with you now, but the truth of the matter is, it's just not worth it. It's much better to hire somebody, my firm or some firm, to do these paperwork, because you have a wonderful opportunity to evict the tenant, and God forbid you lose, you're out thousands and thousands of dollars. It's just not worth it.
Yeah. Anyone you can recommend for San Bernardino County?
I know this firm. It's called Dennis Block and Associates, 1-800-77-EVICT. We handle San Bernardino, Riverside,
Oh, you
LA,
do?
Orange County, and Ventura.
Okay, perfect. All right. I didn't know you did San Bernardino as well.
Oh, we
Okay.
do.
Okay. All right. Well, thank you so much.
Thank you. All right, we are moving on to Jim Murphy. I'm going to ask you to unmute yourself.
Hey, Dennis, thanks for the time on a Saturday afternoon. It's very informative. This is my first try or first attendance. Hey, I am in Manhattan Beach. I have a property that has 2 dwellings on it, and one fronts on Alma and one fronts on Vista. So there's 2 rentals, one in the front, one in the back. I have a tenant in the front who claims that he has rights to create his own patio out in the yard. And I just didn't know if they have the right to do that. I mean, they're renting an apartment up on the 2nd floor, and he claims that that if I don't grant him the space for the patio, that it should be 30% less on his rent.
Well, he's out of his mind. There is no law that says that. You rented him the unit and the unit only. You didn't rent him the common space area. And so unless there was something specifically written in the rental agreement which granted him that right. So tell him that you'll be thrilled that if he tries to deduct, you're not giving it to him. There is no law. Tell him to quote you the law, and tell him that if he decides to short you on the rent, that you'll be thrilled to present him with an unlawful detainer action.
I can't wait. Thank you very much.
You're very kind. Thank you. Let's see. We're going to move on to Z. I'm going to ask you to unmute yourself.
Hi.
Hello, Z.
Hi.
Look at you, that curly blonde hair.
I know you like to see faces, so do I. So I took off my little sticker there. I have a question. Oh, and thank you, by the way, for providing this resources for us. It's my first time here and my first time at this. My parents are property owners, and my father was in an accident, and my sister and I are trying to step in and help them as much as we can without really knowing what to do. But they have some tenants that are in violation of so many things. There was a family of 6 that moved in about 10 years ago. The daughters left, married, came back, brought their husbands back. They have so many people in the apartment. They damaged a balcony, structural damage, all kinds of stuff. they have a full-size refrigerator in the garage plugged into my parents' power, which they've been told about all kinds of violations. I can go on and on, but my question is, I want to make sure I'm following the correct steps to get them out or get an eviction going. We used one of your forms for a 30-day notice to evict, but now that I'm listening to you, I don't know if I did that the proper way, if maybe I should just call your office, or was I supposed to do something prior to that to
What
perform
city
or
again was
quit?
this property?
Oh, sorry, Inglewood, California.
Okay, there's specific notices that need to be served in a situation like this. We also have to serve notices on the city of Inglewood. This type of a case, you definitely need the services of an attorney to prepare the proper notices and make sure that your case is viable. So I would want to take a look at the rental agreement. So this is something, Z, with all, not trying to drum up business, but
No,
it's
I
kind of like, you know, tell me, Mr. Cosmetic Surgeon, how do I do a facelift? It's just not going to work. So, all right. Anyway, thank you very much. But give us a call,
Thank
and I'm
you.
happy to help you personally. You can call me on that early morning number between 7 to 8, and I'm happy to talk to you directly.
Great.
And we are going to move on to, we're going to do some redos here. I've got 4 more minutes here. And let's go to Jay again. You had another question, young lady?
Yes, I spoke to you on a different day. It's about my three tenants on the single rental agreement. I know I have to evict my problematic tenant, and I have to do it for all. Is there a way that I can dismiss the other 2 tenants that aren't violating the rental agreement during the eviction process,
No,
so they don't get
I mean,
affected?
you can, but you got to evict everybody from the unit. You can't do a partial eviction. So if you've got, for everybody listening, you've got 3 tenants in a unit. One of them is bad, the other 2 are good, but it doesn't make a difference. You rent it to a partnership, and if any part of the partnership is bad, you got to get rid of everybody and get yourself some other people in there. Okay?
So there's no way to dismiss the other 2
Well,
during the eviction
if
process?
everybody moves out, if the good tenants move out, you can dismiss them so that there's nothing on their record. But they've got to move out.
Okay.
All right. Well, thank you very much. Ladies and gentlemen, I've got an announcement to make. Today is July 6th, 2024. Now, there was a date, July 6th, 1974. That was exactly 50 years ago today, ladies and gentlemen. And what happened to me on July 6, 1974 was I got married. This is my 50th year anniversary. I am going to end this telecast now because I've got a big affair with a bunch of people in Beverly Hills. So wish everybody a happy weekend. And I've got another speech to do tonight. So take care, everybody, and we'll see you next week.